Well, welcome to the December roundup of Coffee with Compliance. My name is Colleen Patterson, and I'm the Vice President of Employer Services and Compliance here at Savoy. And joining me today is Sara Simkins, who is a Senior Compliance Specialist at Savoy. So, as we've done in the months past, Sara and I are going to be recapping all of the happenings in the legislative and regulatory landscape over the course of the last month. So, we're covering what's happened in December and what we think is impacting employee benefits. So with that, Sara, do you want to get us started?
Absolutely. So first I want to mention that some new guidance has been released on the RxDC requirements, which establishes a limited deadline and enforcement relief for the 2020 and 2021 submissions that were due by December 27th of 2022. So now there's officially a good faith, reasonable interpretation safe harbor, which will give employers a bit of a break when it comes to reporting, as long as they're still making their best efforts. So you still have to report, you just get a little bit of a break. So there will be a submission grace period through January 31st of 2023, meaning the federal government will not consider a plan or issuer to be out of compliance with these requirements, provided that a good faith submission of 2020 and 2021 data is made on or before that date. There are also a couple other things to note with this new guidance. First, multiple submissions are allowed, and email submissions will be accepted at RxDC submissions at cms.hhs.gov. The email submission must include the plan list file, premium, and life years data, meaning the data file D1, and the narrative response. The name of each file should include the reference year of submission, the plan list or data file type, and the name of the group health plan sponsor. In addition, entities do not have to report the amount of any RX spending that was not applied to a deductible or out-of-pocket maximum. So there are columns for this spending on the D2 and D6 data file templates. Plans do not have to include this data, and if they're not including it, they should leave the data fields in these columns blank. And I also want to mention that everybody should be aware that ACA reporting season is basically here. So ALEs should furnish 1095-C forms to each of their full-time employees for the 2022 tax year by no later than March 2nd of 2023. For ALEs that choose to file electronically, the 2023 ACA data filing deadline is March 31st of 2023. And if you're doing paper filings, that's due by February 28th of 2023. And as a reminder, employers who hire a resident of New Jersey also have New Jersey reporting obligations to the state, even if the company itself is not a New Jersey company. So this applies to all size groups, not just ALEs and not just fully insured or self-insured groups. And if you have a group which isn't sure if they should report either federally or with the state, we can assist with that determination. And if you have a group which needs reporting assistance, we have a lot of vendors which can help with that both on the state level and the federal level. In addition, the IRS has permanently extended by 30 days the deadline for employers to distribute individual statements to full-time employees that specify whether the employer-sponsored health insurance plans meet ACA requirements for minimum essential coverage. So essentially, this is a deadline for furnishing the 1095-B or C forms, which is permanently extended to March 2nd every year going forward, provided the date is not, of course, a weekend or a holiday. So this doesn't change the due date for filing with the IRS, but now it has made permanent what was already in place before, which is the March 2nd extension for filing these 1095 forms with your employees. And finally, I want to give everybody a reminder to update your documents as your plans renew. If a group doesn't have plan documents, this is the perfect time to get them in place. Every group, regardless of size or whether they're self-insured or fully insured, must have an SPD in place at minimum. The Section 125 plan documents are also required for any group which uses pre-tax deductions to pay for benefits. As a reminder, the carrier will never provide these documents. They are employer specific, and the employer has to be the one to either create them or hire a third party to create them on their behalf. So even if the carrier gives you something and says this is your SPD, it most certainly is not your SPD. This is something that is very specific to the employer, and the carrier actually wouldn't have the information required to make these documents on an employer's behalf. So that's all I have for this month's roundup, Colleen. What can you share with us?
Thanks, Sarah. So there really hasn't been a ton that's been going on this month. However, there are a couple of important things to note. So the first one happened on December 8th, and that's when the House voted to pass legislation that was called the Respect for Marriage Act to protect same-sex and interracial marriage. And then on December 13th, President Biden actually signed the act into law. So while the act does not set a national requirement that all states must legalize same-sex marriage, it does require individual states to recognize another state's legal marriage. So the push for this vote on federal legislation that was protecting same-sex marriage, it really started to gain momentum after the Supreme Court overturned the Roe v. Wade case back in June. So the act classifies the definition of marriage really for purposes of federal law as between two individuals that is valid under the state where the marriage occurred. So in the event the Supreme Court overturns its 2015 Obergefell versus Hodges decision that legalized same-sex marriage, a state could still pass a law to ban same-sex marriage, but that state would also be required to recognize a same-sex marriage from another state. Although this act doesn't really require employers to take any specific action with regard to current employment policies, it does reaffirm that employees in same-sex marriages do continue to enjoy employment benefits and other anti-discrimination protections as they have since Obergefell. In addition to being protected from discrimination and harassment based on sexual orientation and gender identity, which falls under Title VII of the Civil Rights Act of 1964, and of course any other applicable state laws, employees in same-sex marriages are also extended leave protections under the Federal Family and Medical Leave Act, so of course that's FMLA, and certain states and local unpaid and paid leave laws. So we wanted to share all this information again because as we're approaching a new calendar year, it's really important to remind employers that they should review their handbooks and any other employment policies, specifically those that are relating to anti-discrimination, paid and unpaid leave entitlements, and any other benefit offerings to ensure that there's compliance with the applicable federal, state, and local laws. And this new act certainly would be one of those. The next topic that I have here that happened recently, and this is really just a reminder of what's coming, but before I get into details, let's take a step back here and spend a couple minutes talking about the extension of telehealth and HSA relief because it's actually going to be expiring. So it was all the way back in 2020 when Congress had passed the Coronavirus Aid, Relief, and Economic Security Act, and we all know that to be the CARES Act, which permitted HDHP, so that's high deductible health plans, to provide telehealth services, even those that were unrelated to the testing or treatment of COVID-19 at low or no cost prior to the deductible being satisfied through December 31st, 2021. So this is going way back. This meant that individuals could receive telehealth services pre-deductible at low or no cost without jeopardizing their HSA eligibility. Then fast forward, Congress extended this relief under the Consolidated Appropriations Act of 2022, and that's known as the CAA of 2022. And that then set the expiration of this relief to be December 31st, 2022. So that's just in a couple of days. There are a few compliance concerns, though, that we wanted to just touch on here and then talk about. So then what do groups do now that this date has approached and is passing? So the compliance concerns to think about is that there's coverage of free or low-cost telehealth services prior to meeting the high deductible health plan minimum deductible could jeopardize someone's HSA eligibility. Also, current temporary relief permits high deductible health plans to provide these telehealth services to preserve HSA eligibility. However, of course, that's ending December 31st, 2022. And high deductible health plans that provide coverage as described beyond December 31st, 2022 could impact the ability of plan participants to contribute to an HSA. This is also true for standalone telehealth plans that provide similar coverage. So having said all of that, what do employers do who sponsor a qualified high deductible health plan and also provide telehealth coverage? Well, the most important thing is they want to be able to preserve participants' HSA eligibility. So in order to do that, employers want to make sure that they review their plan design with their carrier TPA to ensure that the telehealth services are subject to the high deductible health plan deductible, with the exception of preventative care, of course. And that begins on January 1st, 2023. Or they want to make sure that they review and confirm the telehealth program does not provide significant benefits for medical care or treatment, or that it limits telehealth benefits to preventative care services only. So there's definitely a couple of actions that the employers want to take just to ensure that their telehealth program reverts back to the way it was prior to this extension. Now, we've certainly heard that many experts and health professionals are calling for permanent adoption, arguing that access to these telehealth programs have increased access to healthcare, and it's helped bridge the gaps of healthcare inequities. However, we haven't heard anything about this extension actually continuing, so we have to assume that it is not. And should there be any other further decisions or anything else that does occur around this, we certainly will share that with everybody. But as of right now, it is set to expire December 31st, 2022. So we want to ensure that plan sponsors definitely make sure that they have their programs adjusted accordingly. So they want to make sure, as Sara mentions all the time, that your SPDs and your plan documents are up to date, and then also that you notify your plan participants accordingly that this change is happening. So that is it for us for this month. As always, should you have any questions, please reach out to your dedicated Savoy team and continue to use all of the resources that are available on our website at savoyassociates.com. From all of us at Savoy, stay healthy and safe, and we wish everyone a happy new year. Thank you for joining us today.